Welcome everyone. We are live with another episode of Level Up Law, where every Tuesday at noon, South Carolina Legal Services levels up your legal knowledge about an area of law that we practice in. I'm attorney Susan Ingalls. I'm here in the background with our producer, Kenneth Elliott from our IT department. And you are viewing attorney Jessica Shultz in our Greenville office. Jessica is the lead probate attorney for South Carolina Legal Services. And today, she's going to provide you with sort of a roadmap of basic estate administration, which is going to be really important for those of you who are anticipating probating an estate or currently probating an estate. So it'll be really good information. But before we get started, we do want you to know that this is not legal advice. It's just general information for the public that we give every week. If you need the help of a lawyer, you can always call our intake line here at South Carolina Legal Services or apply online, and that information will be provided to you at the end of today's presentation. So we'll talk about that at the very end. And just so you know, the webcast is being recorded, and so all of our episodes are posted to the Level Up Law playlist on our YouTube channel, usually within about 24 hours. Kenneth's very quick on the trigger with that. And we will post a recording of today's episode there pretty quickly. So be sure to check out our social media because we post those videos every week. And we also have a lot of other resources that we alert the public to on a regular basis. So check out that social media and like and subscribe to our YouTube channel, of course, and you can get all the up-to-date information that we're providing in our Level Up Law series. And also you'll know as soon as a new video is posted. So all of that, the website, social media, handles, and so forth can be found on that last slide of today's presentation as well. And just one other note, Jessica will be answering your questions today. So be sure to put those in the question box if you have any. I'll be watching for your questions while she's speaking, and so we'll get hopefully some answers for those questions as we're going along. Now remember that she can't give particular legal advice about a particular matter, but she can answer general questions about the subject matter. So now I'm going to go ahead and turn it over to lead probate attorney Jessica Shultz.
Thank you, Susie. Can you hear me okay?
We sure can.
Okay, perfect. I appreciate the introduction. Just to give you guys a quick little snippet about me, I graduated law school in 2019. Right out of law school, I clerked for a year for probate judge Amy McCullough in Richland County. And then I joined legal services as a staff attorney and now probate lead attorney. So I'm happy to be here today. Please feel free to put your questions in the question box and I'll answer them as we're going. Typically, I like to make my presentations pretty collaborative. And like Susie said, I can't answer specific legal questions, but I can answer basic general legal questions, and I can answer, to the best of my ability, your hypotheticals. Let's get started. So first, I just wanted to kind of tell you about what probate courts do. Just in case you don't know, they do administer probate estates, and I'll describe what those are on the next slide. Probate courts also issue marriage licenses. They appoint and oversee guardians and conservators. They process involuntary commitments. They hear and decide estate and trust litigation, and they also oversee adult and juvenile mental health courts. Every single county in South Carolina has a probate court, and I'm out of the Greenville office, so this presentation does it should be helpful in any probate court that you might be working with in the whole state. However, because I do work primarily in Greenville, this will be catered to Greenville estates. So the forms will generally be the same, but if there are, just check with your local probate court just to see if there are any minor differences. So if you're familiar with probate, if you're not, you'll soon learn that it's very form-based. So all forms that I'll reference during this presentation, I'll provide you with the form number and also a screenshot of an example of the form. But all forms can be found online through the South Carolina Courts website, and they can also be picked up at your local probate court. And as I said, while most forms are universal across the whole state and every single county, each local probate court might have just a different version of one of these forms. So just be sure to check with them before you're filing anything. All right, so what is probate? Probate is the legal process for transferring someone's property to their heirs or devisees after they have died. This person who has died is called the decedent. So if you hear me reference someone as the decedent, that just means the person who's passed away. And this process is done through an estate administration. So I do want to distinguish between what is an heir and what is a devisee. An heir is a person who is entitled to inherit from someone's estate if they did not own a will. So that's through the statutes of intestate succession, where intestate means the decedent died without a will. I hope that makes sense, and if it doesn't, feel free to submit any questions to me and I'll answer them as they come through. And then you have your devisees. So a devisee is a person who is designated to receive under someone's will, and they may or may not be an intestate heir. For example, if I were to leave a will, leaving everything to my fiance, because we're not married right now, he would be a devisee. He would not be an intestate heir, because if I were to pass right now as someone who is not married and has no children, my parents would be my heirs. So the will allows you a little bit of leeway to nominate and to to give assets to those who might not be your natural heirs. And finally, testate just means the decedent died with a will. So you have intestate is without a will, and testate is with a will. So there are some different types of estate administration. You have your small estate, your full estate, and your taxable estates. So for your small estates, that's where the value of the whole estate, so everything that the decedent owned, is valued at less than $25,000 and contains no real property. These types of estates can typically be opened and closed in the same day, and they can be initiated, so the paperwork can be filed 30 days after the decedent has passed away. For a full estate, these can be administered formally or informally, so that just means with a lawsuit or without a lawsuit. And these should be opened 30 days after the decedent passes away, but must be opened within 10 years of the decedent's death. If more than 10 years have passed since the decedent passed away, you will no longer be able to open their estate, and your actions you can bring in probate court are more limited. Typically, full estate administration lasts about an entire year. And then your taxable estates. So taxable estates are very large. The federal tax return limit are estates right now that are $11.7 million or higher. So at least for legal services, we're not likely going to see that. But if that's the case, the estate progress might look a little different than the administration I'm going to walk you through today. If that's the case, just be sure to speak to a probate estate elder attorney, because this presentation is for basic estate administration, right? So how to open an estate. I did a presentation previously, which has been posted to our YouTube channel. I have the link here, and I'll ask that the link be posted underneath this video that walks you through how to open either a small estate, so you have less than $25,000 or no real property, or whether you're opening a full estate, which is more than $25,000, and or the decedent owns real property. So I'm kind of skipping past that stage for the purpose of this presentation. So we're jumping in, starting on a small estate, and this is under the assumption that you have already filed the small estate affidavit, so the small estate opening paperwork, and the court has now processed that paperwork, and you have now received the small estate order. So the small estate order is called the Order for Payment or Delivery of Personal Property pursuant to small estate proceeding, which is quite a mouthful, I know, but I'm just going to call it the small estate order from the probate court. So after you've turned in all the required documents for opening, the probate court will provide them back to you with a clocked copy, and they'll also give you an order. They should give you several copies of this order. One for every asset that needs to be transferred. And the order should state who is to receive what asset. So the order will reflect the decedent's will if one was filed, or the order will reflect intestate succession and provide which heirs received what share of the property. I have an example for you on the next slide that I'll get to in just a moment. But once you have that estate order in your hand, the small estate order, you need to distribute assets, right? So if there's a bank account, you can take that order to the bank, provide them with the certified copy, and they will review the order and cut the checks from the decedent's bank account as the small estate order tells them to do. If there's a vehicle that the decedent owned that the order distributes, you need to take that order to the DMV along with a copy of the vehicle title, and you'll complete the DMV Form 400 and transfer the title accordingly. If there's a life insurance or an insurance policy that's paid to the estate, let's say the decedent didn't name any beneficiaries on their insurance policy and it does have to go through probate, you can mail the order to the insurance company and they will ensure proper distribution pursuant to the order. So those are a couple examples I have about how to transfer what assets this decedent might own. You can understand like different situations where someone maybe owned personal property and the order will tell you how to properly distribute that personal property and so on and so forth. But essentially what it comes down to is you should receive several copies of the small estate order, and you'll take a copy of that order to wherever you need to transfer the asset. So to the bank, to the DMV, to insurance companies, so on and so forth. Once the assets have been distributed properly pursuant to the order, the small estate administration is complete. So as soon as you have ensured that the assets have been properly divided, for example, you've taken the order to the bank and the bank has issued the checks for the heirs or the beneficiaries, that's the end of the estate administration. There's really nothing else for you to do. Usually there's no need to prove to the probate court that you did distribute the assets pursuant to the order, but each court, like I said, functions a little differently, right? So some courts might want to see copies of those checks that the bank cut for each heir. That way there you can rest assured that that money was divided properly pursuant to the order and was given to the heir it was supposed to go to, right? Like I said, each court will function a little differently, so just be sure to check with your probate court to see if they're going to want proof of those transfers. This is an example I have of a small estate order. As you can see here, there were 9 siblings. Yes. So this was a intestate estate, so there was no will. And there were 9 siblings. They were all children of the decedent, and they were each to share a 1/9 interest of his bank account. So in this example, the heir who is administering this estate would take this order to the bank, and they would cut a check. So they divide the decedent's account 9 ways and cut a check for each heir. So there would be 9 checks coming from this estate. Okay, so that's really all you need to do for small estates. It's pretty straightforward. It's pretty much open and closed. Like I said, it's basic small estate administration. There can be little things that come up, maybe where heirs don't get along, or maybe where a certain entity doesn't quite know how to process a small estate order. If you run into any of those issues, I do advise getting some sort of legal consultation. I'll provide you information on how to apply to legal services on the last slide of this presentation, but just be aware that sometimes there can be a few hiccups, right? Okay, so this is how to administer a full estate. So similar to where we jumped in for small estates, I'm jumping into full estate administration, assuming you've already filed the paperwork to open. So again, if you need to know how to do that, I did do a presentation for that specific point, like how to open the estate, and we'll put that link in there for you. Okay, so at this point in your full estate administration, whether you had opened it informally or formally, you have the certificate appointment in your hands, right? So this is the certificate that appoints you as the personal representative of the estate, and it includes any restrictions or limitations that the court gave you, if any. This is the official document that allows you to conduct business of the estate. So at this point, you are the fiduciary of the estate, meaning that you must act in good faith, and you must safekeep the estate's assets until it's time to distribute them. Okay, so what must be done immediately upon appointment? The first thing you have to do is make sure the notice to creditors is published. Now, most probate courts in South Carolina will do this step for you. There is a creditor fee that you'll pay when you do open the estate. It does vary from county to county, but that's what this does. So immediately after appointment, the personal representative is required to publish the notice to creditors. Publication is to be made once a week for 3 weeks. And as I said, in some counties, the probate court handles this for you. So creditors by law have 8 months from the date of first publication, so the first time it runs in the local newspaper, of this notice to file a claim against the estate. There is an additional timeline, so they have 8 months or the 1-year anniversary of the decedent's death. Whichever comes first, that's when the creditors are barred from filing any more claims. It's typically in the estate's best interest for the personal representative to not pay any creditors outside of the probate process. If a creditor wishes to be paid, they must file a claim against the estate. I do want to give one caveat, of course, if the debt is secured, for example, there's a mortgage on a house or a lien on a vehicle that the personal representative or the heirs would like to maintain, they do need to make those payments, right? And the payments can be paid from the estate account, if any. Because of course, if the mortgage isn't paid, the house can be foreclosed on. If the vehicle payments are not made, the vehicle can be repossessed, right? But generally, for unsecured debts, you don't want to pay them. The personal representative should force the creditor to go through the probate process to consider being paid. Okay, this is an example of the notice to creditors form. Like I said, most courts will complete this for you, so you don't really have to worry about it. If you do have to complete this form, it's pretty straightforward. It's your own information, the decedent's information. And then towards the bottom, you will have someone at the newspaper sign off on this form for you to turn into the court. Okay, so you've been appointed personal representative. You have either you or the court has taken care of the notice to creditors. What must be done in the next 30 days? And that is your information to heirs and devisees. So within 30 days after your appointment, you must give information about your appointment as personal representative and the probate of a will, if any, to all devisees and heirs by mailing them a copy of a form called Information to Heirs and Devisees. While you provide this form to the heirs and devisees, and remember, heirs is anyone who would inherit from the decedent if there were no will, and devisees are those who are to receive from the decedent's will. You must file the proof of delivery with the court. So I'll have an example for you in a moment, but your proof of delivery is your proof to the court that you actually mailed this form out, right? Okay, here is the information to heirs and devisees. And you'll see it's pretty straightforward. If it was an informal appointment, you'll just check those boxes. If it were formal, you would select those. If there's a will, of course, select that there was a probated will or testacy. If there wasn't, just feel free to ignore those boxes and check the appointment. If there's a will, you just provide the date of the will. If there are any codicils, include that date. And then also include whether or not you have been bonded. And as you see at the bottom, you'll just fill out your own information as personal representative. And if you have an attorney assisting you, the attorney will take care of the attorney paragraph. If you don't have an attorney, just leave that part blank. This is your proof of delivery. So this is the form that needs to go to the court, evidencing that you have mailed this form to all the heirs and devisees. What I like to do is make a copy of this form to provide to the court along with my proof of delivery. That way they actually have a copy of what I sent all of the heirs. I'd like to document everything, make sure the file is full and complete, right? So for this proof of delivery, you would just write in on the blank lines, information to heirs and devisees, a copy of which is attached here too. And then you can serve it any of the ways below. So personal delivery, you can hand it to whoever the heirs may be. You can send it through first class mail, registered mail. I like to send it certified mail just because you do get that return receipt back. And that's further evidence that you properly provided notice to the heirs and devisees. Finally, you'll just list the heirs under name, of course, and then their addresses. That way the court has a full list of everyone who has received this document. All right, the next step, what must be done within 90 days? So within 90 days of your appointment, you must file the inventory and appraisement. This is to list all of the assets that the decedent owned and to value them. So you really need to take care to discover all of the decedent's assets, to properly list them, and to properly value them. Because this form is telling the court exactly what the decedent owned and exactly what needs to be transferred to the decedent's heirs or devisees, right? So if there's real property, you should list that. Often you need to include the tax map number and also the deed book and page number. You can pull that from your local register of deeds office. And depending on the county, you can actually just search the county's tax assessor's office for that piece of property, and it'll come up and it should provide you the tax map number, the address, a link, or hopefully at least a reference to the deed book and page, and really all the information you need to provide to the court, right? When you're assessing the value of real property, you do need to be careful. A lot of times personal representatives will choose to list just the tax assessed value, and that's usually too low because if that property were to be appraised, depending on the current situation of the property, of the market right now, it might be much higher than what the tax assessed value is. The reason that matters is because if the real property is ever sold, the value given on the inventory and appraisement will be the base value, right? So whatever the house is sold for over that value that was listed on the inventory and appraisement, the seller may be liable for capital gains tax. So if you list the real property for the lower tax assessed value, and then it's sold for quite a bit higher value, the difference may be subject to a pretty intense tax. So just be aware of that. I know appraisals can be expensive. They're like between $300 to $500. Sometimes it's worth it paying that on the front end to avoid the tax consequences on the back end. With vehicles, the vehicles need to be listed on the inventory and appraisement. They can be valued through Kelley Blue Book, My Car's Value. That's usually what I use. You can enter in the VIN number, or you can enter in the car's make, model, year, mileage, and its appearance, if it's its condition, if it's been damaged, so on and so forth. And they'll give you a approximate value. The other way you can have a vehicle valued is also, of course, going to a dealership and having it appraised. And then for personal property, you should value that at resale value. So think garage sale value. So if you have like a dining room set, think of how much you could sell it for at a garage sale or an estate sale. The only personal property items that usually I don't value at garage sale or resale value are things that have been appraised. So maybe valuable jewelry is the best example I can think of. Maybe a family heirloom that has a certificate of appraisal attached to it, things like that. Otherwise, just try to use your best, use your intuition, use your best guess. And if you ever need to amend the inventory and appraisement, you can do that. You just have to get this first one in within 90 days. So upon receipt of the inventory, a court cost will be assessed and billed to the personal representative. The court cost will be a very small percentage of whatever the total value of the estate is based on the inventory and appraisement. And the personal representative will need to pay that court fee either personally and then seek to be reimbursed, or they could use estate assets to pay that fee. Speaking of fees, generally the personal representative is entitled to a 5% commission based on the appraisal value of personal property of the estate, sales proceeds, and so on and so forth. So the personal representative not only has an interest to complete the inventory and appraisement as a fiduciary of the estate for the well-being of the estate and the heirs and beneficiaries, but also because they're actually going to more than likely receive a 5% commission on whatever this value is. Let's see, I talked about real property. Oh yes, if so on this inventory and appraisement, you also have to record what bank accounts the decedent owns. You'll need to list the bank's name, and I think they ask for the last 4 numbers of the bank account number. If you're not quite sure where their decedent banked, or you're not quite sure what might be left in their bank account, you can take your certificate of appointment to that bank and request a copy of whatever bank statements they might have, and you can use that information to transfer onto the inventory and appraisement. Similarly, if you know the decedent owned vehicles, but you're not exactly maybe sure how many or where, you can go to your county's vehicle tax search and type in the decedent's name, and that should come up with a list of all of the vehicles the decedent owned. It may or may not contain the vehicle's VIN number, but it should give you enough information to give you a start. If you're needing copies of vehicle titles, just take your certificate of appointment to the DMV and request the duplicate title. Okay, here is an example of the inventory and appraisement. You'll see for Schedule A, that's where you'll list the real estate. So you list real estate even if it was owned jointly with another person, if they were tenants in common. You do not have to list it if the title says joint with right or survivorship, because if the title is joint with right or survivorship, that means it's not a probate asset and it doesn't have to pass through probate court. B lists any stocks and bonds that the decedent might have owned. C is cash and bank accounts or anything that might be owed to the decedent. D is life insurance that is paid to the estate. So most often when someone takes out a life insurance policy, they will have selected beneficiaries. If for some reason a beneficiary wasn't selected, the insurance will be paid to the estate and have to pass through probate court. For E, you can list jointly owned property, but reporting is not required, and that means jointly owned with right of survivorship. F is pretty much anything else, tangible personal property, so that includes household goods, furnishings, it's your vehicles, your boats, motors, trailers, your mobile homes that are not fee-titled. It includes airplanes, equipment, interest in partnerships or unincorporated businesses, artwork of value, coins, guns, jewelry, so on and so forth, anything you can think of. And if you need more space than the 4 lines that they provide you, feel free to create another sheet. I mean, it can even be a handwritten notepad, or it can be done on Word to add more personal property if that's needed, right? G talks about transfers during the decedent's life payable to the estate. So transfers that were intended to take effect at death needs to be recorded. That's often seen in trusts, maybe a life estate. H is powers of appointment. So that's where you list property, both real and personal, over which the decedent possessed a power of appointment, whether testamentary or otherwise. That would also be maybe if the decedent was trustee over someone's trust, or if they were personal representative over someone's estate. I is for annuities and IRAs payable to the estate. And then finally underneath, you see your encumbrances. So that's where if there's a mortgage on one of the pieces of real property under Schedule A, you will list that mortgage, who it's through, and the amount of the debt. If you aren't quite sure, this is another situation where you can use your certificate of appointment to contact the mortgage company and ask for the most recent mortgage statement, right? So after you've listed all of the assets, be sure to value them, right? How we've talked about to value them. And then also list how much the percentage the decedent owned of the property. So for example, if a decedent owned a piece of real property joint with their spouse, but not joint with right of survivorship, just tenants in common. That means the decedent only owned half of that real property. So you would write a 50 in the column where percentage owned by decedent. If you have any questions about the inventory and appraisement, feel free to ask. It is a pretty complex document. Sometimes if you've gotten this far without an attorney and you feel like you need a little extra assistance in hunting down assets or making sure you're valuing them properly, I always suggest to at least go sit with an attorney, get them to review this document with you, just to provide you that peace of mind.
Hey, Jessica, a question on the values. Can you use things like eBay and Craigslist to determine values?
Yeah, I think that's actually a pretty helpful tool to determine what the resale value would be of certain personal property items. So maybe if you could find that exact item on eBay or Craigslist and it could give you a ballpark value of it, I think that's more than welcome to use. Yes.
Okay.
All right. So while you're in the process of administering the estate, maybe you're working on the inventory and appraisement, maybe you've already filed it, be sure to have your bookkeeping on order. So at this point, you've probably established an estate bank account. So whatever, some personal representatives do it differently. If the decedent owns several bank accounts, sometimes they'll leave them as is and then distribute them properly at the end of administration. Other personal representatives will consolidate the bank accounts into one estate account. So if there were 4 accounts the decedent owned at maybe 4 different banks, the personal representative can decide to go to any one of the banks or a completely different bank with their certificate of appointment and have those 4 bank accounts consolidated. That helps with record keeping, and that's how I prefer to have it done because it's very easy to trace exactly where the money goes and where it should go, right? So just be sure while you're administering the estate to keep proper accounting records. If you have established that estate bank account, make sure you have the statements of the accounts that you have consolidated into the estate bank account, evidencing that all of the money that was in those accounts at the date of the decedent's death was properly consolidated into this one account. And then if you are paying for any estate expenses, be sure to document that. I always tell my personal representatives to be really careful on spending anything from a state bank account, just because you, as the fiduciary, you have to make sure it's all properly done, right? Or you could be held personally liable for any expenditures that were not an estate expense. Estate expense are your court fees, most court fees associated with estate administration. And I have a list that I'll get to in just a moment, but maybe any final expenses of the decedent, and also any expenses used to preserve the assets in the estate. So that would be paying the mortgage with the estate bank account. That would be something that is usually okay. Again, if you have any questions, whether or not something might be an estate expense or not, feel free to consult with an attorney and they should be able to help you out. But like I said, document everything. Document receipts if you have them, document invoices, anything you can possibly think of, please document. Because sometimes if there is an estate, let's say there's a deduction on the estate account and you can't quite remember where it came from, if you're doing it at final accounting at the end of probate, the court, they won't be suspicious, but they're going to make sure that you properly spent those funds, right? But by keeping proper books and proper accounting, you will have no trouble at the end when you do that final accounting. Okay, we are thinking about, we're coming up to the point where it might be beginning to think about closing the estate, right? So if necessary, this is when you should probably file a tax return for the decedent, and you can do that on your own or through a certified tax preparer. But if the decedent worked at any part of the year before they died, you should file an income tax return on their behalf. The estate may be owed a refund, which you could put into the estate bank account, or they may have a tax debt, which would need to be paid. To file the tax return on their behalf, you should apply for an employer identification number, an EIN. If you've already opened an estate bank account, you probably already have this number, but this functions as an identification tool to file the tax return, right? So if the property in the estate continues to produce income after the decedent has died, for example, from bank accounts or stocks, or even rented property. So one of the pieces of property the decedent owned is generating rental income in the excess of $600 per year, you might want to file a fiduciary return for the estate on that continuing income that has been earned after that person has died. I always recommend you consult with a CPA to determine if the income the estate has generated surpasses that $600 number, and then also how to properly prepare that fiduciary return if needed. So you have the income tax return to settle any tax issues when the decedent was still living, and then you potentially have the fiduciary return for any income the estate earns after the person has passed away. So all income, whether payable to an individual before death or after death, it is reportable typically, and it does need to be addressed to the IRS in some way or another. And just be aware that a personal representative who fails to file the required tax returns may incur personal liability to the IRS because of the unpaid taxes, penalties, interest. Again, it's just best meet with the CPA. They should be able to tell you pretty quickly what you need, what you don't need, but always err on the side of caution. All right, so we're gonna say we are now right before it's time to close the estate, right? So coming full circle, we're coming back to the claims. Our notice to creditors has been published 8 months ago. So 8 months after the first publication to notice of creditors, or the 1-year anniversary of death, whichever comes first, the period for filing creditor claims expires. At this time, you need to evaluate the claims that have been filed against the estate and determine if they are valid debts, which means whether or not the decedent owed the debt and if the amount of the debt is correct. If you need more information to determine whether or not the debt is valid, because oftentimes when a creditor files a claim against the estate, it's just the claim form and maybe a quick summary of the account, right? You're welcome to reach out to that creditor and ask for an itemized detailed accounting. So you must respond to each claim using an allowance or disallowance of claim form, and the form must be mailed to the creditor. Of course, I always recommend you send it certified. And then just like with the information to heirs and devisees, you need to file proof of delivery with the court evidencing that you provided the creditor that allowance or disallowance, right? So if the debt is valid, you may allow the claim. And that's just saying that you accept the claim as valid. That does not mean, excuse me, that you're saying the estate has sufficient assets to pay the debt. If the debt is not valid, you can disallow the claim. If you disallow a claim, the creditor has 30 days from the date of service, so the day you mail it to that creditor, to file a summons and petition for allowance of claim with the probate court. If that happens, you'll receive, you'll be served with that summons and petition, and you'll have to go to a hearing, and that's where the creditor will have to explain to the court that the debt is valid, present evidence, maybe that itemized accounting, and the judge will determine whether or not the debt is valid and whether or not it should be paid. However, if no action is filed, you're not served with the summons and petition within 30 days, that debt is forever barred and it falls off of the estate. Now, if you are owed anything from the estate personally, if you need to be reimbursed for any estate expenses that you personally paid, you might want to file a claim against the estate with an itemized list of the expenses you paid on the estate's behalf. For example, if you personally paid the funeral costs, if you personally paid any of the court costs, any of the administrative costs, so on and so forth, and you believe you are owed that money from the estate and you seek reimbursement, you should file a claim against the estate before the creditor claim period ends. That way the court and all the heirs and devisees can be aware that you're seeking reimbursement for those funds. Okay, so what if there are more valid debts than there are assets in the estate? There is a hierarchy for the way the personal representative is supposed to pay the claims. The first one are the costs and expenses of administration. So that means the attorney, if any, who assisted you through the administration. Reasonable funeral expenses, of course, for the decedent, and other estate expenses that we've already discussed. Your second tier are reasonable and necessary medical and hospital expenses of the last illness of the decedent, and then any medical expenses paid under Title XIX, which is Medicaid. 3 are your deaths and taxes with preference under federal law, and then under state law, and so on and so forth. And if you need help trying to figure out which claims fall in that hierarchy, again, reach out to an attorney and they should be able to help you out. Okay, this is the allowance or disallowance of claim form. So for this form, you'll fill out the creditor's information, and that information you'll be able to pull from the claim that they filed with the estate. So they'll give you their name, address, telephone number, email, if any, if there was an original creditor, the claim amount, the date it was filed, etc. Then you can choose to allow the claim. As I said, that means you're accepting it as a valid debt of the estate. You believe the decedent did owe that money and that the amount is correct. And again, this is not saying that it will be paid. This is just saying it's a valid debt. You can also partially allow the claim. So if you think it's a valid creditor, but maybe the decedent didn't owe exactly the amount they're asking for, you can partially allow it. So you can allow it up to a certain dollar amount, and you're welcome to write in your explanation for that there or not. And then you can also disallow in full. So maybe you don't think it's a valid claim. I've also seen it done where it may or may not be a valid claim, but there are absolutely no assets to pay the claim, so you can disallow, and in your explanation you can write something like no liquid assets in the estate or insufficient estate assets to pay claim. That usually works. And then you sign off on it and you mail this certified mail to every creditor that has filed a claim. And of course, cater the form to each creditor. So if you have 4 different creditors, make sure you do 4 different forms with the proper creditor's information on each form. All right, so once you've gotten through the claim portion, you've dealt with all the claims, now it's time to distribute the assets. I strongly recommend that no assets be distributed from the estate until all the creditor claims have been resolved. So until either they fall off the estate after those 30 days, or they've been resolved, you allowed them partially and they've been settled, and the creditors have filed the release of claim with the probate court. Now you can start thinking about distribution of assets. The reason I strongly recommend that you don't distribute assets until the creditors have been dealt with is because if you, if maybe let's say there's a bank account and you go ahead and distribute that bank account and the creditors find out that there actually were funds to pay their claim, but you went ahead and distributed them anyway, the personal representative can be liable for that amount. So you want to protect yourself and you want to protect the estate, right? But now, if all the creditors have been dealt with, I'll walk you through how to distribute the assets. So if there's real estate in the probate estate, you need to have a deed of distribution done. This is a legal document and it should be prepared by an attorney. Every step that I've walked you through so far, you can do on your own. This is the one where pretty much every probate court is going to tell you, please go get an attorney to draft this document. The reason being, the deed of distribution has to contain the proper legal description for the property being passed, and that can be kind of tricky to copy properly if you don't have legal training. Not saying it's impossible, but it's very, very strongly recommended to have an attorney draft. That way you ensure title is proper. And I have an example for you of a deed on the next page. But this is the form that transfers any real property that the decedent owned to the beneficiaries or heirs who are to receive it. To transfer a vehicle, kind of similar, you fill out the back of the title with the names of whoever is inheriting it, and you sign off. So on the back of the title, you're going to see a block for seller and a block for buyer. You don't have a block for someone who is an heir or beneficiary, which is a little strange when you're trying to figure out how to fill out the form for probate, right? So you will sign the seller's block as personal representative. So it's going to look like you as personal representative is selling the vehicle to the heirs or beneficiaries, but just no money is being passed, right? So in addition to that title, you'll also need to complete a DMV Form 400, which is a title application. And that's where you can explain to the DMV that this is passing pursuant to the probate code. In addition, with the title and the title application, you take your certificate of appointment to the DMV, and they will process that paperwork and issue a new title with the names of the heir or beneficiaries who are supposed to receive that, right? To distribute cash to the proper heirs, you should calculate their percentage of the estate's liquid assets and ask the bank to issue a certified check from the estate account to that heir. Make sure that you're pretty careful about calculating these percentages. And if the estate is passing through a will, right, the will should tell you exactly how everything needs to be divvied up and given to the beneficiaries or the devisees. If the estate is intestate, so it's passing to the heirs, depending on what level of intestate heir they are. So is it a spouse, is it children, is it grandchildren? Each one will receive a different percentage. So that's something that an attorney can help you out with too. But whatever distribution you're making, please document everything, especially if it's anything to do with liquid assets. Of course, make copies of the checks so you can provide that to the court as evidence that you did transfer that money properly. For the title, I always, after it's been filled out by the personal representative, I always make a copy of the front and back to provide the court. If you are transferring personal property, so jewelry, let's see, furniture, things like that, do a little quick, almost bill of sale type document. So I, personal representative, am providing heir this bedroom set and on this day and time, and this is assuring I've transferred it. Some probate courts have forms to kind of assist you with this. I know Greenville has a form called an affidavit of distribution of personal property. That's a form I've only seen used in Greenville, but it is a helpful form. And then you also can collect receipts from the heirs. So it's a form 401, I believe, and I'll have an example later on for you. But it's just saying that the heir received what they're entitled to and they sign off on it. But here's that deed of distribution. So you can complete the basic information on it. For example, when the decedent died, maybe the tax map number, the street property address. But for the legal description, I strongly advise leaving that up to an attorney to assist with you. You'll select whether or not the property was being transferred pursuant to a will, through intestacy, through agreement, and so on and so forth. On the second page, you'll list either the heirs or beneficiaries who are to receive that property, the percentage they're inheriting, and then also their address. This does have to be witnessed by 2 individuals, signed by the personal representative, and notarized. After this form is completed, it needs to be filed with the Register of Deeds in the county where the property is located. So if I were trying to pass a piece of property in Richland County, I have properly executed this deed of distribution, I would go to the Richland County Register of Deeds, pay to have this recorded, which makes it a public document, and then file that recorded deed of distribution with the probate court as evidence of my transfer. Here is the DMV Form 400. This can be found on their website. It can also be picked up in person. And you fill out the information of the vehicle, so the VIN, the make, model. You will fill out the new owner's information, so the heir or devisee. You do need to have their driver's license number or social security number to properly pass this form, which is kind of difficult when you have an heir who won't give you either of those numbers. Still working on how to pass a vehicle when you don't have that information now. So if I learn, I will update you guys. Lien information, if any. That's the other thing. So if there's a lien on the vehicle, you won't have the title to it, right? And you won't be able to obtain title to it until that lien is paid off. So you can either pay off the lien using estate expenses in the estate as an estate expense through the estate account, or you'll just have to close the estate with the vehicle not being transferred yet, and whoever is wanting to receive the vehicle typically makes those lien payments. Then whenever the lien has been paid in full, the personal representative can go back to probate court and then receive permission to then transfer that title. So it slows the process down a little bit, but there is a way to get around it. All right, we are ready to close the estate. You have done everything you've needed. You have transferred all the assets from the estate, and we're ready to close. So there are two ways to close an estate. The first one is if all the heirs and beneficiaries are cooperative, which is what we would prefer, right? But we don't always see that. But there are three forms. The first one is a waiver of statutory requirements and beneficiary receipt and release. This needs to be signed by each heir or beneficiary, and it waives the personal representative's requirement to file other closing documents, the accounting, proposal for distribution, and the notice of rights and demand hearing, which we'll talk about in just a moment. Secondly, the personal representative needs to sign a waiver of filing requirements. That's a 364. And that's the personal representative themselves seeking to waive the additional closing documents. And then finally, an application for settlement. So that's the form that lets you know that you've completed estate administration and that you were asking the court to close the estate. All of these documents are to be filed directly with the court for processing. And of course, these are the typical forms you have to file. If your probate court maybe functions a little differently, they might have another form for you to complete, but these are the typical closing documents. So this is your first form that each and every beneficiary need to sign. This is the waiver of statutory requirements. They always make sure they read through it. They understand what exactly they're waiving. They can list the items that they've received from the estate on that blank line, but it's not required. They don't have to do that. And then it just needs to be dated and signed by them and then notarized. This is the personal representative's personal waiver of statutory filing requirements. As you can see, you would like to X or initial the three required documents: accounting, proposal, and notice of right demand hearing, and then dated, signed, and notarized again. And then here is our application for settlement. This is where we are telling the court we have fully administered the estate, and we're asking the court to close the estate. So you'll check the boxes. If proof of publication was necessary, then you would check that it was done, that you have completed the inventory and appraisement. If necessary, you have filed a proposal for distribution. If necessary, a final accounting, or not necessarily if it's been waived, proof of delivery, that tax returns have been completed, that the time period for creditors' claims has expired. And for number 5, you would just ask, select the box which best fits your case for the court to close, right? So if you are filing the additional documents, ask the court to consider those. If you've already made distributions, ask the court to approve them. And if there are more distributions you need to make, you're seeking the court's authorization to do that. And then asking the court to discharge the conditions of personal representative, which just releases you any bond that you might have. All right, so how do you close an estate? if heirs and beneficiaries are not cooperative, if maybe there's a holdout, maybe someone doesn't feel comfortable signing the waiver of closing documents for you, you will have to file these additional closing documents. So the first one is an accounting of the entire estate administration. So this is where your bookkeeping and your very careful record keeping comes in handy, right? Because you have to account to the court every asset that the estate received during estate administration. So if the estate was earning rent, that would be something the estate received. Or, and you also have to account for all disbursement or bills that were paid out of the estate. You also have to file a proposal for distribution. So that's where you indicate assets that have not yet been accounted for or not yet distributed and your plan to distribute them. Your application for settlement, which we just went over, and then your notice of the right to demand a hearing. So this notifies each heir or beneficiary of their right to demand a hearing for the court to hear any concerns they may have about your administration. So these forms are all to be filed with the probate court and a copy provided to each heir or beneficiary with proof of service. Of course, that Form 120 that we've talked about before, right? All right, this is your accounting. So you see on the page to your right, the left-hand side is where you'll list the assets received into the estate. Right-hand side, disbursements and distributions that have been dispersed from the estate, right? Your proposal for distribution. So on the left-hand column, you'll identify the heir or beneficiary. And then on the right-hand column, you will list the item or the amount of liquid assets that are to be given to that beneficiary. And of course, this proposal needs to be in line with the decedent's will or statutes of intestacy, unless the heirs have agreed to otherwise. But I'm not getting into that because we're trying to stay basic, right? Your application for settlement, which you've seen before. And then your notice of the right to demand a hearing. So this form alerts heirs and beneficiaries to their right that they do have to demand a hearing from the probate court, just in case they had any issues with the way or questions with the way you were administering the estate. They have 30 days to demand this hearing in writing. If they don't demand a hearing within 30 days, that they no longer have the ability to do so, and the court can go ahead and close the estate. Okay, so like I said, if after 30 days, an heir or beneficiary doesn't request that final hearing, you may proceed with making your final distributions and complete any final requirements from the court. This might include receipts from the beneficiaries, which is a Form 401, releases of creditor claims, copies of transfers, so copy of transferred vehicle title of the new deed of distribution. Upon receipt of all the final closing documents, the court will review everything you filed, let you know if there's anything else they need from you, and then they'll issue an order closing the estate. So here is just a simple receipt where the heir or beneficiary can list exactly what they received from you and they can sign off on it. This form doesn't have to be notarized, but it should be witnessed by someone who is not the personal representative. Here is the order closing estate. So this is the order that discharges you as personal representative. You have done your duty to the estate, you have properly transferred everything, and you have honored the decedent's will or honored the laws of intestacy. And if you were bonded, you can take this order to the bonding entity and they will release that bond for you. So I just wanted to give you a quick disclaimer. Like I said, some probate courts require additional forms. These are the forms that should be required in every probate court in all of South Carolina. But like I said, different counties might require additional forms, or they may have their own version of a form that they've tweaked a little bit. Just be sure to check with them. And I've only covered basic estate administration. So if there is litigation, if anyone files a petition within the estate, that's when you should probably seek out an attorney's assistance to work through that litigation. The court won't be able to give you legal advice. They can generally help you, give you instructions and directions on how to complete forms to a certain extent, but they're not allowed to give you legal advice. I always like to throw this slide in. Maybe as you're going through the probate of a loved one, you're starting to think about your end of life planning. I have a presentation I do on advance directives, and another attorney, Taylor Ott, has done a level up law, and I have that link here on Keep It Simple, Elder Law 101. But advance directives are really for anyone, no matter what age you are. I do recommend having these documents done. For leaving a lost will and testament, potentially trusts, your powers of attorney, your living will or your do not resuscitate order. Having these documents will help your personal representative work through your estate when that time comes. And if any of you have ever probated an intestate estate, it is much more difficult than if the decedent had left you a will. So if you have any questions about that, feel free to reach out to legal services and check out this YouTube link here, how you can really prepare for your end of life. All right, here is our legal services information. You can apply online or you can call our intake service. It's called Lattice. We're open Monday through Thursday, 9 to 6. It does stay pretty busy, so if you get a busy tone, just keep calling. I promise we'll get to you. As Susie said, be sure to check us out on social media. We stay pretty active. And I appreciate you listening. And if you have any questions, feel free to send them in the comment box. Otherwise, thank you so much, and I hope that was helpful.
Thank you so much, Jessica. That was awesome. I want to thank you for an excellent presentation. You just went through all the basics of probate estate administration, just as you promised, and I think this will be a really helpful video for a lot of people. So thanks so much for such a great detailed presentation. You hit it right on an hour, so I will quickly say to our audience, thank you for being with us. And if you found this video helpful or this webinar helpful, which I'm sure you did, and if you think it'll be helpful to others that you know, definitely go to our YouTube channel tomorrow at SC Legal Services and share the broadcast so we can reach as many people as possible. We want as many people to get this important information as we can. And again, while you're there, like and subscribe for more. And if you sign up for notifications while you're there, you'll get a notification each week when we post a new episode. But of course, we do invite you to check us out and join us live every Tuesday at noon. So be sure to tune in next week for another episode of Level Up Law. And thanks again for tuning in today. Thank you to our presenter, Jessica Shultz, lead probate attorney for South Carolina Legal Services, and behind the scenes, Kenneth Elliott, our producer. That concludes today's webinar. Thanks, everybody.
Thank you.